Welcome to this explainer. Look, if you're a parent in Connecticut, you already know that your child's success is your absolute top priority. But did you know that really understanding state and federal education law is kind of the ultimate toolkit for ensuring that success? It's true. Today, we're breaking down the official Connecticut Parents Education Toolkit to help you know your rights, really understand the law, and ultimately become the best advocate possible for your student. So here's our roadmap for today. We're going to cover 1, the foundations of parent rights, 2, accessing education records, 3, navigating special education, 4, the age 18 transition, 5, attendance and homeschooling, and finally 6, some practical tips for success. Let's jump right in. Section 1, Foundations of Parent Rights and the Balance of Power. Okay, let's set the stage with a foundational premise. In Connecticut, you play a central, crucial role in your child's education, and that role is heavily protected by both state and federal law. But while your rights are incredibly powerful, they aren't totally absolute. The state actually makes it clear that your access and participation rights have to be balanced against things like student privacy, school safety, and the basic operating procedures of the district. So it really helps to think of this as a partnership rather than some sort of adversarial relationship. At the end of the day, you and the school are on the same team. Moving on to Section 2, accessing education records, or unlocking the files. So this is your most basic fundamental right, the ability to see exactly what the school sees regarding your child's educational journey. Now, you've probably heard this alphabet soup before, but let's demystify it. FERPA stands for the Family Educational Rights and Privacy Act. Don't think of this as just dry, bureaucratic jargon. Think of FERPA as your literal personal key. It's the federal law that protects your child's privacy from the outside world while legally guaranteeing that you, the parent or guardian, have direct access to their academic, health, and special education files. So what can you actually do under FERPA? Well, you have the right to inspect and review these files. And if you find something in there that's just downright inaccurate, you actually have a formal process to request an amendment. You can also track exactly who outside the school district has accessed your child's file. The biggest takeaway here for you, you should proactively ask for copies of absolutely anything that affects educational decisions. We're talking meeting notes, evaluations, attendance reports. You have a right to this information, so don't be afraid to ask for it. Section 3, navigating special education and your meaningful procedural rights. We're pivoting now to special education. This is an area where Connecticut law provides some incredibly specific and robust protections for families. The framework for the whole shebang is IDEA, the Individuals with Disabilities Education Act. And listen, while navigating special ed can sometimes feel like you're just drowning in a sea of paperwork, this federal law is exactly what guarantees you a literal seat at the table for every major decision involving your child's special education needs. It ensures you get notices at key points and even provides guidance on things like in-school observations so you can participate without disrupting the classroom instruction. The special education process generally moves through 4 main steps. Step 1 is evaluation and observations. Step 2 is eligibility determination. Step 3 is IEP planning. And finally, Step 4 is placement decisions. And here's the thing, you have a right to be involved at every single one of those steps. Also, as students receiving these services get older, Connecticut publishes a specific transition bill of rights for parents. It recognizes that your involvement remains totally vital as everyone starts planning for things like employment and post-secondary education. Now, this brings us to one of your absolute strongest procedural rights. If you disagree with the school district's evaluation of your child, you have the right to request an independent educational evaluation, or IEE. This is a crucial, game-changing leverage point for parents who feel like their child's needs just weren't fully or accurately assessed by the school. Section 4, the age 18 transition. This is a major shift in power. As I just said, this is a major shift, and honestly, it's a critical turning point in this explainer. What legally happens when your child reaches the age of majority in Connecticut? I want you to think about this for a second. You've spent 18 years holding the keys, right? You've been signing the IEPs, requesting the records, making the ultimate decisions. What actually happens to all of those educational rights the exact second your student blows out those 18 candles? Yep, 18 is the magic number. In Connecticut, the age of majority is 18. At this exact age, a massive legal transfer takes place. State and federal law actually mandate that the district must formally notify both you and the student that this huge shift in rights is occurring. It's a pretty stark contrast. Pre-18, you have full access and all the decision-making power. Post 18, boom, those rights transfer entirely to the adult student under IDEA and state law unless a court has formally found them incapacitated. But there is a very crucial exception you need to know about. Your adult child can provide written notice to the district, allowing you to continue making educational decisions on their behalf. You really need to plan for this transition period. Section 5, Attendance and Homeschooling. Let's look at some special scenarios. Let's see how all this builds into specific real-world scenarios. Both truancy and the choice to homeschool require immediate, structured action from you as a parent. Take the number 10. That is the exact number of school days a district has to hold a mandatory meeting with you if your child becomes officially truant. Connecticut law recognizes that when attendance becomes a concern, having the parents involved is absolutely vital to figuring out what's going on. We really want to frame this truancy process not as a punishment, but as a legally mandated timeline for the school and the family to team up. Step 1 is tracking those repeated absences. Step 2 is getting that mandatory meeting on the calendar within 10 days. And Step 3 is the real goal here, collaborating early to solve the underlying barriers. Whether it's a chronic illness, a lack of transportation, or severe anxiety, the key is to communicate early and document the issue long before academic progress takes a hit. Now, what if you decide to go the homeschooling route? Connecticut definitely allows homeschooling, but it comes with some real responsibilities. Step 1, you absolutely must notify the district superintendent's office. Step 2, you have to create a plan for the educational process as required by law. Step 3, you need to maintain your own records. And listen, it is extremely important to know that Connecticut does not accredit homeschooling institutions, nor does it recognize their credits like a public school would. The responsibility for that falls entirely on you. Finally, Section 6, Practical Tips for Success. Let's build your action plan. It is time to bring everything we've learned today together and turn all this legal knowledge into a really practical, everyday action plan for family engagement. I want to anchor our final piece of advice in this great quote from Connecticut education policy. Schools and families are expected to work together early. Just remember, while schools don't have to grant every single request exactly the way a parent wants it, respectful, written collaboration is absolutely the key to making this partnership work. All right, here is your ultimate rapid-fire action plan. Ask for copies of records and notices whenever you need them. Keep a written timeline of meetings and school responses. Review those IEPs very carefully before you sign anything. Ask about independent evaluations if you find yourself disagreeing with the school. Plan well in advance for that age 18 transition we talked about. Document any attendance barriers early on. And if you choose to homeschool, follow the district notification rules strictly. Honestly, the most effective strategy you can have is to always communicate in writing, keep copies of your emails, and hey, maybe invest in some extra printer ink. If a disagreement arises, always ask to see the specific policy. Your rights in education remain a huge part of Connecticut school law, but as we've seen today, those rights shift and evolve quite a bit as your child grows into an adult. So my final question to you is this: are you prepared for their next chapter? Stay informed, use this toolkit, and keep advocating for your students' brilliant future. Thanks so much for joining me on this explainer, and I will catch you next time.